All right. Obviously, it's been a lot of hours of going through paperwork, making photocopies, and of course, making sure that we use our good friend, Mr. Sharpie. Of course, this is an off brand Sharpie, but fuck it, it works, right? Now, there's two people that are very key to all of this that, well, for their own safety and also for the protection of what they have to say and for the protection of, well, a lot of people involved, we're going to refer to one at the south end of town here as D, and we will refer to the one at the north end of town as W. When you're in trouble, you call DW, Duckwing Duck. All right. Now, this first one is actually going to have everybody in it. Now, the reason for that is because it's against Leslie Snell, one of my predators. And I got a whole shit ton of paperwork here that, believe it or not, I'm actually still going through and organizing. But I got the stuff with Leslie Snell on her paperwork taken care of pretty decent. So, we're going to go through and we're going to review these things and we're going to discuss the difference between playing victim and actually being victimized. When I go to these guys about people literally threatening to kill me, I'm told there's nothing they can do. And then later on, they want to pretend I'm schizophrenic. Whoa! After being on the news the way I was, you really going to pretend that people would never in a million years do those things? Holy shit. So let's get down to business. Now, obviously, these other three cases that they dropped, well, they have a lot to do with Leslie Snell since her fucking name is on all of them. But we've got to read the paperwork so that you guys are actually aware. I know you want this to be a 30-minute Matlock wrap up. Oh, this ain't fucking TV, dumbass. All right, we'll start with number one. I suppose. Yeah, I had to put a giant number one on them so that I can separate number one from number two. They did a piss poor job, or they did a shitty job. Number one and number two. Now, obviously, we have taken out any protected information, or rather, not taken it out, but taken a Sharpie to it, obviously. We have taken a Sharpie to it. We get to see the names of the judges and public pretenders, and we're actually going to read this shit. All right. It says ex parte harassment protection order. Obviously, I was trying to turn these people in. Now, I suppose I should probably give you a quick primer. Leslie Snell and I went to high school together here in Chapel. Yep. She was a cheerleader. I tried out for cheerleading. I didn't make it. Their reasoning for me not being allowed to be a cheerleader was that they had already ordered skirts. I'm not afraid of a skirt. I'll wear it. The bloomers would probably look a little weird on me. Or would you prefer to call them spankies? If you're a cheerleader, you know what those are. So Leslie Snell, really, we never had a problem except for one time that I confused her for her sister Lynn, and she goes, Leslie has less hair. Cool. All right, I got you. So after high school, there was a lot of years where she lived right next door to my friend Jeff. We never had an issue, never had a problem, never cursed, never yelled at each other, nothing. Hell, when I first started bow hunting, I got most of my arrows used from her husband. I believe he gave me a whole box of them. Now, let's fast forward to, well, a few years in. I'd already tried to turn in Scott decoste and his deputies, and they'd already had me sent to the nuthatch to try to have me pegged as bipolar. Because if I'm bipolar, magically it's okay that they didn't do their fucking job. Apparently. So eventually there's threats and harassment I'm having to deal with here in Chapel over shit that happened in fucking Colorado, or rather didn't happen in Colorado and didn't happen in Virginia. But whatever, right? We'll pretend that that's got nothing to do with this, correct? Lovely. Omitting evidence is the same as lying. I'm trying to show everything. Now, I do have to break down each one of these other individual cases in later videos to show you really how truly easy it was for Leslie Snell to manipulate her position and her intimate knowledge of these other cases and what was going on with them, and coordinate with her boss in order to illegally prevent me from going. That's right. They put me in prison for crimes that weren't even committed, based on slander, legally prevented from even using a telephone. Now, I do have a piece of paper somewhere in this fucking mess that is from one of the guards in the prison about the phone privileges and so on and so forth. I was illegally prevented from even contacting anyone to get help. Illegally prevented from going to this court date. And of course, we're going to have to read this shit for you. Let's get to it, shall we? All right. Leslie A. Snell, Clinton N. Snell, and then two other Snells, whose names are obviously scribbled out of here. It says the protective parties of this order are Leslie A. Snell, Clinton N. Snell, and then blank Snell, blank Snell. The court, having received the petition and affidavit of the petitioner, finds that a harassment protection order pursuant, now this is, they automatically win if you're not allowed to go to court. They automatically find you guilty. You don't even have to show evidence if you prevent them from going to court. Now, they hand you the protection order, so we did the right thing. Really? Did you explain that I was illegally prevented from going, or that I was incarcerated when I was given the protection order, or that it's all bullshit and I was illegally prevented from going because of the incarceration? Meanwhile, it's incarceration on 3 separate charges that they dropped due to lack of evidence that they have to pretend that they had. They have to pretend that they had the evidence. Obviously, they didn't. Obviously, Judge Randon Rowland granted these things based on bullshit. That's right, straight bullshit. You say slander's not allowed in court. Hearsay's not allowed in court. You're a fucking liar. So here's their blustering bullshit. The court, having received the petition and affidavit of the petitioner, finds that a harassment protection order pursuant to Nebraska revised statute 28-311-09 should be issued. Further, it reasonably appears from the specific facts. What facts? The video that they're claiming that they no longer have access to, that video is still up. Do you know why? I didn't threaten to kill anybody. It's literally a video about not killing anybody. It's literally a video where I'm talking about how I am nicer than your God because your God does kill people. The whole video is about religion in hell. That's right. This is a Christian community and it is hell. It reasonably appears from the specific facts included in the affidavit that irreparable harm, loss, or damage will result before this matter can be heard on notice. Therefore, the court, having jurisdiction of the parties, finds that a harassment protection order should be issued without prior notice and hearing. So I don't get a notice or a hearing. But then again, she works for the Dual County Sheriff's Department. They'll give her whatever the fuck she wants. Unfortunately, they were dumb enough to leave a paper trail. All right, it says it is therefore ordered pursuant to Nebraska Revised Statute 28-311.09, unless otherwise dismissed or modified by order of the court, a harassment protection order against the respondent is granted for a period of 1 year from the date of this order, and the petitioner is granted the following relief. Now, mind you, we're going to get to the parts later on where I'm allowed to do something about this. There are things that I am allowed to do. I'm just illegally prevented from doing them due to, well, Randon Rowland being a fucking moron. All right. And you notice that the judge in this is not fucktard Rowland. It's Derek C. Weimer. I wasn't allowed to write him a letter until my last month in prison. Literally, it gives me permission. I got 10 days to try to do something about it. And I was illegally prevented from doing it. Now we're going to get to this because the other video they're claiming where I'm threatening their lives is also still up. Now, a lot of this is bluster and bullshit and fluff, and I am sorry, but it's important bullshit. Some of it, even if you're highly intelligent, it probably is not going to make any fucking sense. Anyway, it says respondent is enjoined from imposing any restraint upon person or liberty of the protected parties, which is literally what they did to me. They took away all of my rights. They imposed restraints upon me. They took away my liberties. Of course, I can't be a protected party, can I? I'm disabled. They can call me mentally ill, and magically, their crimes are acceptable, aren't they? Of course they are. It said if the respondent wishes to appear and show cause why this order should not remain in effect for a period of 1 year, he or she shall affix his or her current address, didn't have one, telephone, that was stolen, didn't have fucking access, and signature on the request for hearing form provided, and return it to the clerk of the district court within 10 business days after service upon him or her. How are you going to do that when you're in prison on trumped up fucking charges? That's right, I was in prison. I wasn't convicted of jack shit and wasn't even charged with felonies. Meanwhile, the Constitution says that's fucking illegal. But we don't live in the United States of America. I live in the shitty state of Nazi Nebraska. All right. And then it says, let's see, within 10 business days after service upon him or her. This order shall remain in effect during the time prior to the hearing. Costs are waived unless otherwise ordered by the court. Dated on January 29th, 2021. This is what, 2 or 3 days after I tried to turn her into the Nebraska State Patrol? Yeah. So I'm allowed to do something, but I'm not allowed to do something. It said, pursuant to 18 USC 2265, this order is enforced in all 50 states, the District of Columbia, tribal lands, and U.S. territories. So an illegal situation here is legally binding everywhere. I told you they did everything they could to shut me up and prevent me from turning these people in. Now, this is the part where I do need to pause and give you a little bit more info on the situation. I'd already been trying to turn in Scott DeCoste since 2018. And it was end of 2019, maybe. But I called up Dual County Sheriff's Department, and the person who had been working there was Destiny Vote. Well, she doesn't work there anymore. And it was Leslie Snell who was there. Well, that's nice. I never had a problem with her. It sucks that she's working for a crooked sheriff. But I had to call her in because I needed to turn in her boss. And of course, I'm told I got to turn it into the Dual County Sheriff's Office. I'm trying to turn it into her, and literally she's snapping at me for trying to turn in her boss. I'm doing what I was told to do. This is how this bullshit started. So then, let's fast forward a bit. I've had to go in and try to turn in my predators on multiple occasions. One of the major issues is a situation with people calling me up from restricted numbers and harassing me repeatedly. And obviously, with officers also calling from restricted numbers, they're literally telling me that they're predators. These officers are doing exactly what the predators do. Their protocols are the exact same protocols that a man who beats the fuck out of his wife uses. You lock her up so she can't tell on you. You lock her in the closet, don't you, until her bruises go away. You take away her keys, you take away her phone, you take away her ability to communicate with anyone. The police do the same thing when you try to turn them in. Now, of course, Leslie Snell, being fully and well aware of these restricted calls and that these are because people are giving out my personal number, she knows that this is going on. She is also well aware. She is already, and I do have this recorded with Scott DeCosta. It might even be on this YouTube channel already, where he's telling me that Leslie Snell is pissed off at me because I spoke out about how she was treating me. And she was especially pissed off that I recorded our phone calls and posted them on the internet. These are not private. Oh, connection is unstable. Please wait while we try reconnecting. Much better. So she's well aware that this situation is going on. The Dual County Sheriff's Department, they're telling me they can't do anything about actual threats and actual harassment. Apparently, it's nobody's job. Now, there's the fact that I am literally needing someone there. This lady from Adult Protective Services is supposed to sit with me and look at evidence and do something about these fucking crimes that the goddamn pigs here aren't going to do anything about. Like, well, the assault by Josh Rayborn, the theft of my property by Josh Rayborn and Amy Spencer, aka Amy Kalina Kingery. So she's the dispatch operator for Dual County. But the dispatch here isn't in Dual County. It's all the way in Sydney, apparently. Cheyenne County, next county over. So, obviously, I can't go to this protection order, being as I was in prison for trying to turn in Leslie Snell and Robert Warnick and Scott DeCosta. And, of course, with Scott DeCosta goes all of his deputies and Leslie Snell. Woo! So she was aware of the restricted phone calls. She was aware, she was right there when I was instructed to get a new phone. I did get a new phone. And when I got that new phone was when I was trying to turn in Robert Warnick. Leslie Snell obviously was holding a grudge. She knew that I had to record my stuff live. Obviously, she had been angry with her own boss because she wanted it taken down. Just like Terry Jepson wants it taken down. Just like Aaron Cockerham wants it taken down. No, I am not taking evidence down. Now, this one right here doesn't have anything on it. It's a basic information sheet about what you're allowed to do, even though you're not allowed to do it. It says a harassment protection order is, well, actually, I suppose I should finish the bottom of the first one, right? Pursuant to 18 USC 2265, this order is enforced in all 50 states, the District of Columbia, tribal lands, and U.S. territories. Moreover, pursuant to I don't know what the fuck that thing is, USC 922 If a final order is entered against you after a hearing of which you had actual knowledge and an opportunity to participate, I didn't have an opportunity to participate. At no point in time was I allowed the opportunity to participate. Anyway, it says whether or not you actually participated, and if this if this court order restrains you from harassing, stalking, or threatening an intimate partner or a child of such intimate partner, or engaging in other conduct that would place an intimate partner in reasonable fear of bodily injury to the partner or child, you may be subject to a federal penalty for possessing, transporting, or accepting a firearm or ammunition. You stand up to the motherfuckers, they do everything they can to take away your Second Amendment because you exercised the first one. Why do we have the Second Amendment? To protect the First Amendment. Now let's make sure that we actually get this in focus. We want everyone to know that obviously everything that I just read is true. I am truly reading what it said on here. Fucking goddamn it. All right, we'll put it up real close. All right, there it goes. That's just page 1. There's actually, I guess this is like page 2 of 10. I didn't actually get a page 1. And this was served to me right after the situation that Meg was talking about, where there was a court thing in Scotts Bluff and she wasn't allowed to speak there either. Literally right after that, after the judge, Brandon Rowland, the fucking crooked piece of shit. God damn, there's a lot of bad judges, ain't there? We need a system that fucking works. This one don't. This one eats up our time, our money, our resources, and kills innocent poor people. We're on to page 2. Now, when I was handed this right after court, they made sure they did it after court. That court was, what was it, February 4th or February 5th? When I was handed this, it says a harassment protection order is a court order issued to a victim who has been harassed pursuant to Nebraska Revised Status 28-311.09 exsec. So, like, they're not even writing this in understandable fucking language. They're going out of their way to make sure it's not written in English, so that even lawyers who look at it need to have a few extra degrees to even understand what the fuck is going on, and even then they don't know what the fuck is going on. According to Meg, Audrey Long didn't know what the fuck was going on in my case. That's recorded. Of course, not in those words. It says, in order to qualify for a harassment protection order, the petition shall state the events and dates of acts constituting the alleged harassment. This must include the most recent and most severe incidences. Oh no, I made a video about how I'm not willing to kill people. Oh my God, we gotta freak out. Hide the dog. It says the petitioner must show that the respondent has engaged in a knowing and willful course of conduct directed at the petitioner, which seriously terrifies, threatens, or intimidates the petitioner, and which serves no legitimate purpose. It served a legitimate purpose, first of all. I was trying to turn in crimes committed against me. I was trying to figure out why it is that Robert Warnick, after assaulting me, and after I had tried to turn him in, was still walking out and about and stalking me after assaulting me. What is the progress on this? Now, she, after knowing full well that I have to record it, obviously she'd been angry about it, and knowing full well about the harassment from the restricted numbers and how that was preventing me from being able to answer calls from any of these so-called professionals who are literally also supposed to call me, and they're calling from restricted numbers. They tell me to ignore the phone calls from the restricted numbers, and then they tell me I got to answer it, and they tell me I got to change my number. I did change my number. I had just changed my number when Leslie Snell went out of her way intentionally more than once, knowing exactly and precisely what she was doing. She did so with the intent of doing some of the things here. Now, obviously, I get blown off no matter what. They call me mentally ill, and these people's words must be worth more than evidence, but they had to do something to guarantee that I could not counter this. They had to break the law to guarantee that she would win, because it helps all of these predators, all of them. Every time that they pull one of these dealies, it makes me out to be a bad guy. You think they're going to admit that I was illegally prevented from going because they broke the law to prevent me from going? Not likely. I've got actual evidence against them. They've got slander, and in order to win the slander, they got to prevent me from going. Now, in none of this paperwork at any point in time does any of this admit that I was incarcerated and could not go. This is a common tactic when you try to turn in a police officer. A very common tactic. But it's okay, right? Now let's continue. It says a course of conduct is defined as a pattern of conduct composed of a series of acts over a period of time, however short, evidencing a continuity of purpose, including a series of acts following, detaining, restraining the personal liberty of stalking, telephoning, contacting, or otherwise communicating with the petitioner. Calling 911. That's apparently against the law. Now, obviously, my personal liberties were denied. I was stalked. Even over the telephone. And obviously, I didn't want to contact her. I wanted to contact someone who's going to do their fucking job, not someone who's going to go out of their way, knowing full well and intentionally what she was doing, intent on trying to make me a target to retaliate against me because of something that was not against the law. It is not against the law for me to record my conversations with people, nor to give their names in a situation like this. She works for the Dual County Sheriff's Department. She is a part of the situation. Yeah. It says a protection order may prohibit the respondent from imposing any restraint upon the petitioner or family or household member or liberty of the petitioner. I'm avoiding her like the fucking plague. I limited the time that I went to pump and pantry to a very small fucking window. That window is when I am least likely to run into Robert Warnick or Leslie Snell. No fucking brainer here. Let's see. It says harassing, threatening, assaulting, molesting, attacking, or otherwise disturbing the peace of the petitioner. Is telling the truth disturbing the peace? Is showing evidence disturbing the peace? Because in just a couple of pages, we're going to get to the slander. It's provable that it's slander. Let's see. Telephoning, contacting, or otherwise communicating with the petitioner. Obviously, I am making zero attempt to call 911. I am making zero attempt to call the Dual County Sheriff's Department. I am making zero attempt to call or even speak to them. So no contact whatsoever. If I see somebody who looks like her, I'm going to go the other way. I drive completely away from her house. Now, there's a quick route from where I'm at now to the post office. Now, if I want to go to the post office and completely avoid all of my predators' places, it adds like an extra 13 fucking blocks to the walk. That's not an imposition. That doesn't restrain my liberty. Does it? How about locking me up for crimes that didn't commit? That doesn't restrain my liberty, does it? It said once the protection order petition is granted, it may not be withdrawn except upon order of the court. You mean the court that illegally prevented me from turning these people in? You mean the court that had me imprisoned based on zero goddamn evidence? You mean this same court Well, that's pretty fucking screwball, ain't it? Let's see. It says the protection order shall be effective for 1 year unless otherwise modified by the court. Of course, I'm illegally prevented from fucking going, ain't I? Hell, I even got a thing from Judge Weimer, who I wrote a letter to, saying that he wouldn't fucking read it. Who the fuck do I go to? I wasn't even allowed to have the information I needed to contact that fucking judge to let him know what the fuck was going on. Everything has to be handled through a lawyer, but not a public fucking pretender. Obviously, I don't have the goddamn money for a real fucking lawyer, or I wouldn't have a goddamn public pretender. Let's see. A court, on its own motion or at the request of the petitioner, may treat a petition for a harassment protection order as a request for a sexual assault protection order or domestic abuse protection order if it appears from the facts in the petition, affidavit, and evidence presented at the show cause hearing that such other protection order is more appropriate. Well, obviously, she's not going to accuse me of domestic abuse. I don't live with the dumb cunt. Obviously, there's going to be no request for sexual assault bullshit because I didn't fucking touch the dumb cunt. Notice to respondent. I'm the victim, not the respondent. They got the roles fucking reversed. It said, if there has been an ex parte protection order served upon you and you wish to request a hearing to show cause why the order should not remain in effect, you must request a hearing on the provided request for hearing form by completing the form and turning it in to the clerk of the district court at the address listed at the bottom of the form. You must return the form within 10 business days after you have been served. Well, what if you are illegally prevented from going to court? Leslie Snell already knew. She already knew because of the position that she works in and the man that she works for. The fact that she processes all of their fucking paperwork. She got to see all of this other stuff and abuse her position to guarantee I couldn't go to court. But did she write that down? Of course not. Did she write down that I was in fucking prison on false charges? Of course not. Let's see. The court will schedule a hearing within 30 days after reviewing our request and shall notify you and the petitioner of the hearing date. Except, in this case, they went out of their way to illegally prevent that. They didn't bother to look at any actual goddamn evidence. So, of course, this Judge Derek C. Weimer piece of shit is a fucking moron too. But then again, he's got a position of power. He can do what the fuck he wants, can't he? Let's see. It says, if there is a hearing scheduled and you wish to defend against the claims set forth in the application for a protection order, you must appear at the hearing. You are warned that if you fail to appear, the case will proceed without you and a final order may be entered against you for the relief requested in the petition. You are required to obey the terms of the protection order as soon as it is served upon you. If you disobey the terms of the protection order, you will be subject to the following Nebraska revised statutes. Violation of a protection order. Any person convicted of violating the terms of a harassment protection order after being served shall be subject to either Nebraska Revised Status 28-311.04 or 28-311.094. If a protection order has been issued against you, the following United States federal statutes apply to the issuance of a valid protection order. Meanwhile, it's invalid. This protection order is invalid. I was illegally prevented from going to court, and illegally prevented from having access to legal materials. This is against the law. Let us continue. Now, obviously, this is why I needed a protection order against Scott DeCosta before he got to take it out on me for trying to turn him in by assaulting me. I needed a protection order against Robert Warnick and one against Ted Bollinger. And of course, one against Leslie Snell. Let's see. Full faith and credit provision. I've got no faith. You're going to have to show me evidence. Now, obviously, I could be looking at the camera right there and glare. Ooh, scary. But instead, I look up in the corner here because that's where it'll tell me if I'm disconnected. Let's see. Full faith and credit provision. So your credit score has more to do with anything else? Your credit? Are you fucking shitting me? It says full faith and credit provision. Pursuant to 18 USC 2265, this order is enforceable in all 50 states, the District of Columbia, tribal lands, and U.S. territories. The penalties for violation of this order are determined by the existing penalty of the location in which the violation occurred. Nebraska's harassment, full faith, and credit provisions are found in Nebraska Revised Status 28-311.10. I don't even know what the fuck that is. Interstate domestic violence violation of a protection order. If you travel across state or tribal borders with the intent to injure the petitioner and then intentionally commit a crime of violence causing bodily injury to the petitioner, you may be convicted of committing a federal offense under 18 USC 2261A1. You may also be convicted of committing a federal offense if you cause the petitioner to cross state or tribal borders for this purpose. So basically, forcing somebody to have to flee state is also against the law. But the thing is, you have to be able to obtain one. And you don't get to obtain one when you have to go to Joan Hanson, who's going to fucking bullshit you. Fuck you, Joan! That's right. Small town, everybody knows everybody. These people work together. Obviously, they're not going to lift a goddamn finger to see if their coworkers actually do their fucking jobs. If their coworkers not doing their jobs gets people killed, these people will go out of their way to protect their coworkers. Let's see. So that's page 2. We've got 9 more of these to go through. Fucking damn it. Come on now. Oh. There's got to be a way to do this. Maybe if we move this. Obviously, this doesn't have any protected information. It doesn't have her phone number on it or any of that fucking bullshit. So I didn't have to blank anything out of it. So then we get into the real bullshit, the real nitty gritty. Of course, my good pal, the Sharpie, is helping me to show you guys the truth. Now, mind you, I didn't know Leslie's daughter's names until I got this piece of paper. I'd literally never talked to them. Ever. Yeah, Leslie Snell is afraid. She's afraid of going to fucking prison. It says petition an affidavit to obtain harassment protection order. Filed January 29th, 2021, Dual County District Court. In the District Court of Dual County, Nebraska. See, she filed this knowing already that I was going to be in jail and probably already being aware that I was going to prison without trial and would not be able to do anything. Meanwhile, we got to look at the rules in the jail book that are going to show you, well, how being in prison illegally prevents you from going to these things anyway. And then you'll get to see when I start getting into the abuses in the prison, holy fuck, that's a mess. It says in the District of Dual County, Nebraska, Leslie A. Snell, petitioner, case number CI 21-2. Clinton N. Snell, additional petitioner / minor children. Clinton is not a minor. That's her husband. He's older than, and she's pretty full. She's older than I am.